Many business owners register a limited liability company and immediately assume that a shareholder and a director are the same thing, but they are not. A shareholder owns shares in a company while a director manages that company. One person can actually occupy both positions, but each position comes with different powers, responsibilities, and risk. If you do not understand the difference, you could give some ownership of your company when you only intend to give them a management position. You could also appoint someone as a director and mistakenly believe that person automatically owns the business or part of the business. So in this video, this very important video, I will explain the differences between a shareholder and a director in very simple terms and show you what every business owner should know before registering an LTD with the CAC. Meanwhile, if you want us to help you carry out any of your business processes, maybe CAC registration, or you want to carry out any of the CAC post-incorporation services like annual returns for your business, increase or decrease in share capitals, change or edit of your company directors, shareholders, or you want to do any of the compliances about your business at all, tinted glass permit for your car, NIN, BVN issues, whichever it is that you're struggling with, you can always reach out to us. I will be willing to help you. Our contact details is in the video description just below this video, and you can always reach out to us. I will be very glad to have you and to help you fix any of your issues. So first, let us understand what an LTD really is. When you register a limited liability company, the company becomes a separate legal entity. In simple terms, the company becomes legally separate from its founders, its shareholders, and its directors. The company can own property, can open bank accounts, can enter into contracts, can borrow money, can sue, and also be sued in its own name. Therefore, even if you own 100% of the shares, the money and the property belonging to that company are not automatically your personal property. You control the company, but you and the company are still legally separate. Now, let us discuss these two major positions. Who is a shareholder? Now, a shareholder is a person or organization that owns shares in a company. Think of the company as a cake. The shares represent the portions into which that cake has been divided. So if a company has 1 million issued shares and you own, let's say, 600,000 shares, that means you own 60% of the company's shares. If another person owns the remaining 400,000 shares, that person owns 40%. Now, a shareholder can be an individual or another registered company. However, a company cannot ordinarily act as a director. A director must be a natural person. A private company in Nigeria can also be formed by just one shareholder. This means one person can own all the shares of that company. What does a shareholder do? The main role of a shareholder is ownership, not daily management. Now, depending on the number and class of shares held, shareholders may have the right to vote at a general meeting, receive dividends when lawfully declared, approve major company decisions, appoint or remove directors through the proper procedure, approve changes to the company's article, approve an increase or reduction in share capital, approve a change of company's name, transfer or sell their shares subject to the company's articles and the law, and receive a portion of any remaining assets just if the company winds up after debt has been settled. However, owning shares does not automatically give a shareholder the authority to sign contracts, operate the company's bank account, or manage employees. Those management powers normally belong to the director or other authorized officers. So, who exactly is a director? Now, a director is a person appointed to manage the affairs of the company and make decisions on its behalf. If the shareholders are the owners of the vehicle, for instance, the directors are the people sitting behind the steering wheel, okay? Now, directors decide how the company will operate subject to karma, the company's article and decisions properly reserved for shareholders. They may approve contract, supervise employees, manage company's finances, develop business policies, and ensure that the company meets its legal obligations. A small company may have only one director. Other companies generally require at least two directors. So, what are the responsibilities of a director? A director is not merely a name placed on the CAC documents. A director has legal duties to the company. Directors are expected to act honestly, use their powers for proper purposes, and make decisions in the company's best interest. They must avoid conflicts between their personal interest and the interest of the company. If a director has a personal interest in a proposed transactions, that interest should be properly disclosed. Directors must not secretly divert company's opportunities, money, or property to themselves. They should also exercise reasonable care and attention. Directors are also involved in ensuring that statutory filings, financial records, and other compliance obligations are properly handled. This is why you should never appoint someone as a director simply because you need another name on the CAC application. Being a director is a position of legal responsibility, not a ceremonial title. So, can one person be both a shareholder and a director? The answer is yes. This is extremely common in small businesses. For example, if you establish a company, own all its shares, and manage its operations as a single person, you may be both the sole shareholder and the director, provided the company is qualified to have one director. But remember that you are wearing two different hats. As a shareholder, you make ownership decisions, and as a director, you make management decisions. The paperwork should reflect the particular capacity in which you are acting. So, can a shareholder not be a director? The answer again is yes. Someone can invest money and receive shares without participating in the daily management of that business. So, for example, let's say Amaka owns 40% of a company but appoints an experienced director or experienced directors to manage it. She remains a shareholder even though she is not a director. She can exercise the right attached to her shares, but she should not automatically take over the director's daily management powers. Can a director own no shares? The answer is yes. A person can be appointed as a director without owning any shares, unless the company's articles specifically require directors to hold shares. For example, a company may appoint an experienced finance professional, maybe as a director. That appointment does not automatically make the person a shareholder. If you want that director to own part of the company's shares, then that shares must be separately allotted or transferred to the person, and the necessary records and CAC filings must be completed. A directorship is not ownership. So, who has more power, the shareholder or the director? The correct answer is it depends on the decisions being made. Directors generally control the company's day-to-day management. Shareholders make certain major ownership and constitutional decisions through general meetings or written resolutions. Shareholders can also appoint and, following required procedures, remove directors. However, an individual shareholder cannot simply walk into the office and cancel a board decision merely because the person owns some shares. The correct voting and company procedures must be followed. A minority shareholder with, say, 20% or 30% does not automatically control the company. However, the company's article or another valid arrangement may give the shareholder special rights, such as the right to appoint certain directors. This is why share percentage alone does not always tell the complete story. How do they receive money from the company then? Now, a shareholder may receive money through dividends when the company as distributable profit and a dividend is properly declared. A director may receive a salary, director's fee, or other approved remuneration for the services provided to the company. If someone is both a shareholder and a director, the person may receive a salary for working in the company and then dividends because of share ownership. These payments are not the same and they should be properly documented. A shareholder should not treat every amount in the company's bank account as personal income. Company money must be used and withdrawn for legitimate, properly recorded purposes. So, what about liability? Now, a shareholder's liability is generally limited to any amount unpaid on the shares held. But limited liability is not a license to commit fraud or ignore personal guarantees. If a shareholder personally guarantees a company loan, for instance, that guarantee may create personal responsibilities. Directors may also face personal consequences for fraud, misuse of company's funds, serious breach of duty, or certain unlawful actions. The company provides protection, but it is not an invisibility clock. Now, I shed more light about this particular issue of liability in this video currently on your screen. I explain better with simple illustrations that you can easily understand in a better sense. You can watch it after watching this video. I will also leave the link in the video description. So, what happens when someone leaves? Now, a director may resign or be removed using the proper procedures, and the change must be filed with the CAC. Removing someone as a director does not automatically remove the person as a shareholder. This is a very important point. So, if Chinedu, for example, owns 40% of the shares and is also a director, removing him from the board only ends his management position. He still owns 40% unless those shares are lawfully transferred, sold, forfeited, or otherwise dealt with under the law and the company's governing documents. In the same way, transferring someone's shares does not automatically remove the person as a director. The two changes must be treated separately. Also, shares are assets that can generally be transferred and may pass through a deceased shareholder's estate, a director's position. However, it's an office. It is not inherited like properties. Now, shareholder is not always the same as PSC. You may also see the term person with significant control or PSC during CAC registration. Now, a shareholder holding 5% of the shares or voting right will generally qualify as a PSC, but the person may also qualify as a PSC without directly owning shares. For example, where the person has the right to appoint or remove a majority of the directors or otherwise exercise significant control over the company. Therefore, shareholder, director, and PSCs are three related but different descriptions. Now, important lesson for business owners to note before you carry out your business structure. Before registering an LTD with another person, agree clearly on the following: who will own the shares, the percentage each person will own, who will serve as a director, who will manage the business daily, who can operate the bank account, how profits will be distributed, what decisions require shareholders' approval, what happens when someone wants to leave, whether shares can be sold to outsiders, and how disputes will be resolved. Do not wait until the business starts making money before having these important conversations. Money has a special talent for turning small misunderstandings into full Nollywood productions. So, your memorandum and article of associations, shareholders agreements, board resolutions, share records, and CAC filing should all reflect the real arrangements. So, in conclusion, here is the simplest way to remember the difference. A shareholder owns shares in the company. A director manages the affairs of the company. A shareholder is not automatically a director, and a director is not automatically a shareholder. And removing someone from one position does not automatically remove that person from the other. Understanding these differences help you protect your ownership, assign responsibilities correctly, and avoid future disputes. If you found this video helpful, please like it and subscribe to this channel and share it with other business owners who are planning to register a limited liability company or who just want to run a legal business either in Nigeria or anywhere in the globe. Thank you, and I'll see you in the next video.